You have one precious life. How will you make your money work for you? It's time for Sage Money Conversations, where your financial happiness and confidence are always the subject. Here's your host, certified financial planner, Barbara Norman.
Hello and welcome to Sage Money Conversations. Today we have with us Rod Hatley, and I feel so fortunate. Rod is a former Navy JAG officer. So if you've ever seen the movie A Few Good Men, that's what he did. And now Rod has 2 law degrees. He is a tax attorney and an estate planning attorney. And we are so blessed to have his knowledge, his generosity, and he's going to share with us today the importance of estate planning documents, what they are, and why we should have them. So Rod, welcome to the show.
Thanks for having me. It's a pleasure to be with you.
So when I think about estate planning documents, this is a big nebulous word. What does that really mean?
Okay, it's a great question. The answer will depend on whether someone has real property or doesn't have real property. If they own a home, especially here in California, and I assume that your podcast is really geared more to a California audience, although maybe it goes out nationwide. But at least I'll tailor my comments for California.
Okay, thank you.
California residents. If you've got a real property, like a home and maybe an investment property, it's really going to make a lot of sense to have a living trust, okay? And if someone doesn't have real property, then it's not going to go through probate when they pass on. A simple will probably be enough. And we'll talk about the other documents that supplement, whether it's a trust or a simple will. But depending on where they are in life and what they may own, a living trust may usually be a really good answer, but sometimes a simple will be enough.
So what's the difference? What's the difference? A will, a trust? A lot of people have the idea,
great.
If I have a will, I'm good.
Okay, a couple things, and it's a great question. If you have a will, I'll pick on myself. Let's say I had no estate plan in place, so you know that I do. But if I didn't, let's say I'm driving home tonight and I get into a bad car wreck. Now I'm mentally incapacitated. My will, if I had a will and that's all I had, it's not going to do me any good. Okay, because now someone's going to need my signature at some point. The way they're going to get it is they put me in front of the probate court judge downtown, and they say, Your Honor, this is Rod. He's incompetent now to manage his affairs. Please appoint me, some third person, to be his conservator. That's a guardian for a grown person. So now I'm in a conservatorship proceeding, which takes time.
Oh, wow. And you have no control over who that person is, do you?
Well, sometimes there'll be a family member will step up, but sometimes it could be someone appointed by the court. It just depends. So to remain in control, I think having a trust-based plan, especially, again, if they own real property, makes a lot of sense. Or even if they don't, and they've got, say, a large IRA, and they want to direct where that's going to go, sometimes that can flow through the trust. It just depends on what they want to accomplish. But to answer your question, if all you have is a simple will, that may be okay. We don't know. But certainly it's not going to do you any good. I mean, in my situation, if I became mentally incapacitated, and then, of course, because wills only become effective when you die, and they only are effective assets owned in my individual name. Let's say that I have a policy of life insurance, okay? That's not going to go through probate. That's going to go directly to the designated beneficiary. So maybe that the assets that I own, if they're beneficiary designation assets that are passed by operation of law, those go directly to the nominated beneficiary. All that person has to do is provide a copy of my death certificate, and then the money is turned over to them. So a will, if I have minor children, a will would be valuable because then I could nominate who the guardians of my children would be. But that's about all that you're going to get with a will. Again, not effective while you're alive, only effective when you die, only effective that those assets owned in your individual name. And if you might have minor children, it can also indicate who you nominate to be your guardians to love and raise your children with your values, etc. A trust, on the other hand, is effective now. So but I always tell people, think about it as kind of like an open top box. Assets go into the box, like your home, bank, and brokerage accounts. It can be the designated beneficiary of your life insurance, your retirement plan monies, if it makes sense to do that. And if I'm driving home, get into that bad car wreck, and now I'm incapacitated mentally, I don't have to worry about going through conservatorship. I've already got successor trustees nominated to step up to the plate, take care of me, take care of my assets the way that I would want. And then someday when I pass, those assets will not go through probate. Those assets owned by or appointed to my living trust will never go through probate. And that's a really good answer where I'm concerned. Part of why I do this now, my father had been a successful businessman But Dad had a simple will, and Dad also had leukemia. So at that point in his life, he's making those emotional choices. And I knew enough about estate planning, being in the Navy JAG, to be able to say, Dad, I think we need to do more planning to get very business interests, et cetera. The reality was he simply couldn't grapple with the fact of his impending passing. So, and you understand why, because it's hard, it's emotional, very, in a way, almost very irrational fear. But anyway, you take your clients as you find them. So anyway, that's why I do this now, is because I've been through a 7-year probate. I don't want to see clients have to put their families through that kind of misery.
What does 7 years of probate look like?
It's unfortunate. Dad passed away in June of 92. We finally wrapped up the probate in September of 99. So
why did it take so long, Rod?
What happened was
stories. Go ahead.
Well, Dad had various business interests, and Dad had also, the way he had set up his businesses and operated them caused questions on the IRS.
Oh.
Okay, and when they got involved, it's, just forget it. I mean, it's, they get involved, and it just takes time. So it blew it out into a 7-year ordeal. And that's not what Dad wanted, but Dad, he'd been successful, but he wasn't the best at receiving good information, doing something with it. And I understand there's fear there, and sometimes there's a little bit of ego. And I just try to help people get past that and say, look, you're doing this planning not so much for you, but for your family and the people who come after you, because you're not going to see a lot of benefit now, but your family will reap the benefit for the, it's the old phrase of, one generation plants the tree, the next generation gets the shade. So it's that kind of idea that we're doing kind of planning now for the benefit of your family, the people who come after you.
Sure. I can see why you are now a estate planning attorney, tax attorney. It seems like you did it by the seat of your pants first. What a way to get an education.
It was, very much so.
Sorry. And the probate courts now, I heard, are just as backed up as can be. So if somebody goes through probate, what is the expected time frame? What is the cost of that?
Yeah. Well, probate just simply takes time. It costs money, and it's a matter of public records. So I just wrapped up a probate back in the August time frame. We opened it up back about March of 19. A young man, unfortunately, had jumped off the Coronado Bridge.
Oh.
And then, of course, the pandemic really kind of slowed everything down. Just nothing was happening. So I figured 2.5 years in that case, but then you had 1.5 years of the pandemic. So I would say probably at least 18 months or longer, just start to finish, and that's assuming a really clean probate with not a lot of assets and not a lot of paperwork having to go back and forth. But, start adding, assets to the mix. And now you've got a much more, things have to be inventoried and appraised and all that sort of thing. If there are multiple beneficiaries or people like that, then it can just really take a long time.
Can I ask you a crazy question? Because
Sure.
If it takes 18 months and somebody has a house with house payment or HOAs, taxes that are coming due, you're talking about appraisals, attorneys, how does all of this get paid for? I mean, can someone lose a house while it's in probate? Like, what goes on with the assets while it's in court?
Well, the best way to answer that is to simply say, if the designated or nominated personal representative, now if someone had a will, then that would be terrific. You would look at the will and say, okay, well, let's say Rod was supposed to be the designated personal representative to shepherd the assets through the probate process.
Okay.
But in the case of the young man who had unfortunately jumped off the Coronado Bridge, he didn't have a will. So we had to administer his estate, and we had to appoint an administrator. That's the term they use in the probate court to get that estate through the probate process. So it just takes time because, I tell people, look, if you don't do your estate plan, that's a choice, but know that the state of California has written a plan for you. It's called probate, and you may not be happy with the results. I always like to ask the rhetorical question, how many financially responsible 18-year-olds do you know?
Right.
Because if you have no plan, or if it's just a will, most people get their, an inheritance at 18. Money doesn't come with instructions, as you certainly know. And so, I think it's just really unfortunate to, leave things to chance like that. So I always encourage people, get out ahead of this. Just know what your options are, get smarter about them, and then make the choice that works for you. I don't care what it is.
Yeah. I remember the day I sat my 3 kids down. They were all 18 and above, and we sat around the table. My girlfriend came in to witness their advanced healthcare directive. And the looks on their faces were incredible. They just, they were astounded. It's like, this is really weird. They didn't want to talk about it. But then when the 3 of them started talking about the organs they would and would not donate and their final wishes, we were just all laughing. It was one of the funniest experiences ever. They still talk about it. So
you were smart to do that. And I did that for my nephew actually shares my birthday. So when he turned 18, I drafted for him what I call a personal protection plan. It's a will, a power of attorney, a healthcare directive, and a Hipaa authorization. And that way, because now he's 18, he's an adult. Mm-hmm. And now his parents, my sister and her husband, have the ability to act on his behalf. Heaven forbid something should happen to him.
Okay,
so he started, college during the, pandemic. And so this gave them a measure of comfort, knowing if they had to, they can now have access to his records, et cetera, which they otherwise would not, even though he's their baby, of course. But he's 18 now, and so that stopped.
Smart. Okay, so those, you just flipped off 4 documents. Those are kind of the 4 basics. Let's go through each one of those 4. What are they? What do they do? And what are the chores of somebody who has to administer that document?
Sure. Let's see. Well, in the case of what I call a personal protection package for my nephew, he got a simple will. Okay. Typically, whatever he has would go to mom, and then mom didn't survive, would go to dad. This is how that would go. And nominated mom to be the primary personal representative. And if she can't do it, then obviously his dad would, all that sort of stuff, Now, power of attorney is helpful because, now remember what we talked about, wills only become effective when someone passes away.
Sure.
What about, my nephew is Kyle. What if he became, heaven forbid, mentally incapacitated as a result of an injury or a disease? Then my sister and then her husband could step up to the plate as his agent under a power of attorney and be able to act on his behalf. Okay. Or, get, pull his college records or whatever was necessary, or interface with the college. He's going to school back in Missouri. So if they needed to act on his behalf, they could do that.
Okay.
So that's the power of attorney. And the Advanced Healthcare Directive, that's what we call it here in California, and the Hipaa authorization, those kind of go hand in hand. And talk about each of them. The Advanced Healthcare Directive says, I'll use my own healthcare directive as an example. If I have to go to the hospital, okay, and I'm really, really sick and I can't speak for myself, okay, I have nominated people that I trust to make those important medical decisions on my behalf. In my own personal case, I don't want to be kept alive artificially. So if I'm in an irreversible coma or a persistent vegetative state, I don't want to be a drain on my estate. So I said, look, just go ahead and pull the plug. And I'm a big believer in organ transplants. I would be happy to donate any organs that could be harvested for transplant purposes to make someone else's life a little better. So I'm a big believer in that. And, other people don't feel the same way, and they may have certain religious, dictates, and that's fine. We can almost always embody into the documents what's important or what's important to the client, so that, their documents say what makes them feel really good about, if they had that situation where they were near death and what have you. So,
right. And that is such an important document. I think back, do you remember the Terry Schiavo debacle? Absolutely. Where her husband, she was in this vegetative state for how many years? Over 7?
And the challenge there was that they had talked about it, but nothing was ever written down.
Yeah,
that big problem. Now her parents get involved because they don't want to lose their child.
Right. He's ready to move on and they're not.
Yeah, exactly. So, and that's the real tragedy there. To round out the conversation, what goes hand in hand with the Advanced Healthcare Directive, and sometimes people call it the Healthcare Power of Attorney in other jurisdictions, in California, Healthcare Directive, is the Hipaa authorization. What Hipaa stands for, it's an acronym, but basically it's federal law, and it says that no one can have access to your protected medical information, take a look at your medical records, talk to the doctors and nurses, unless you have authorized them to do so. So the Healthcare Directive and the Hipaa authorization go hand in hand, and you need to have both. So what I do for my clients is we do both of those. And I also get my clients, and I have it for myself, and I get it for all of my clients. It's a membership in a company that allows 24-hour, 7-day-a-week, 365-day-a-year access to the healthcare directive and HIPAA, because nobody walks around with a copy of these documents on their person, at least not now. And so if I had to go to the hospital, then I've got a card in my wallet that has a toll-free number that can be called 24/7, 365, and a copy of my documents, my healthcare directive, my HIPAA, can be faxed over to the hospital so that my healthcare agents can now step up to the plate and make those important medical decisions on my behalf.
Wow, that's huge. And what is the service that does that?
It's a company called DocuBank, DocuBank, DocuBank.
Okay.
And I get it for 3 years, and I get it for 3 years for a purpose. When I do an estate plan for somebody, we know the world's going to change. We know the laws are going to change. We know their personal situation is going to change, all that stuff. So about every 3 years, when that membership starts to come due, I want to have the clients come back in to see me because I think there's a value. Now, you have the privilege of working with your clients probably once a quarter. You're going to be having a conversation. I like to see the clients if I can get them back in about every 3 years because the world will have changed, things will happen, and I want to make sure that their plan stays up to date. If we keep the plan updated and maintained, much better answer if disability or when death comes. That it's a much cleaner plan to administer.
That is so smart. I think about my clients and say they had young kids and it was a family member who was going to raise them. But then as they got into junior high and high school, it was like, no, we'd want our friends raising them. So yeah, things do change. Life moves on. And I think that's brilliant. I've not heard that before. And I love how you stay in touch with people in that way.
I think it's malpractice not to. I mean, I probably really malpractice, but I think it borders on, in my experience, you can't write a plan one time that takes care of everything for all time. It just doesn't happen. So I say, let's have a relationship because that's really what people I think are investing in. If you want documents, you can get them online, but unless you have a relationship with an attorney who takes the time to get to know who you are, what's important to you, and then drafts your plan so that it's tailored for your specific goals, then you can get anything off the internet, and that's it may or may not work. I don't know, but I think if you want your plan to have success, then I think it's valuable to work with an estate planning attorney who really focuses in this area of the law because the other areas of law that someone could work in, but this is what I chose to do.
So let's do this. So you've talked about like those 4 basic documents, the will, the power of attorney, the advanced healthcare directive, and the HIPAA. Now let's talk about the trust, because this is an area I think that is so important. And I've seen like one of my clients just went deer in the headlights, would not do any planning because they had a drug addicted son. And they haven't known what to do with it. And when I finally poked him and said, hey, look, if you do nothing, your son's going to get a third of your estate, whether you like it or not. And finally, so Rod, those delicate conversations, people just have to get raw and open and vulnerable with you about what's going on in their lives. So let's talk about what that trust will and won't do.
Yeah. And what you posed, I think, is certainly a number of years ago, I worked with a really lovely couple. They had 3 adult kids. They had 2 sons and a daughter. And it was the second son, who I think was the baby of the family. He was the one who had the substance abuse problem. Now, at the time that we met, he'd just celebrated 10 months of sobriety. They were over the moon. But they were concerned that when something happened to them, if he got any money, he was going to drink himself to death. That was a big concern. Now, this is real world stuff. And a very nice family. He was a retired Navy captain. She'd come from a very nice family back east. So, it happens in any family. Okay. These issues pop up.
Yeah.
So we were able to draft their living trust to say that their second son would never have access to his trust share unless he could pass a 5-panel hair screen. And be able to go to the satisfaction of the trustee that he was clean, he was sober, he was staying, on the straight and narrow path, hadn't fallen off the wagon. And that sort of thing, I think, can create comfort in the clients, knowing that someday when we're gone, when he gets his money, if he can show to the satisfaction of the trustee that he's, doing the right things, then he can have access to his money. And if he doesn't, then he has to work with the trustee to dole out money for whatever he needs. Okay. So I think we can design the plan, whatever, is important to the client. So that's just an example of what we can do. Okay. Or sometimes there's an incentive trust. Maybe You want to incentivize a child or perhaps a grandchild. For example, you're going to college, and if you get a part-time job, maybe delivering pizzas or whatever, the trust will match you dollar for dollar your W-2 income.
Oh, wow. I like that.
Oh, and we literally call that an incentive trust. So it incentivizes someone to just not sit there and, collect the money, but to also, hey, go get a job, delivering pizzas or whatever, and we'll match you for whatever your income is. And it's they're bringing in income on their own and also receiving additional matching funds from the trust. And that can be really powerful.
That is very powerful. Who doesn't love a 100% return on your money?
Exactly.
So a trustee, so that's the person who does all of the work when someone is gone. Tell me the duties of a trustee. Are they liable for anything?
Of course. Yeah. When someone sets up a living trust, okay, mom and dad set up a living trust. Mom and dad are the trust makers. That's what I call them. And they're also the trustees. They're also the beneficiaries. So they're all three. Okay. So nothing has really changed except the names on the things that they own that they put into the living trust. Okay. Their home, bank accounts, brokerage accounts, that sort of stuff. But something happens to dad. Dad passes away maybe. And so mom continues on in her role as the trustee. So she's basically going to do whatever she's been doing previously, managing the assets, investing, maybe working with you to make sure the investments grow and are protected, et cetera. At some point, mom and dad are both out of the picture. Okay. And so now there's a successor trustee, which would be possibly an adult child, or it could be family friend, business colleague, somebody that you trust to, discharge the duties. Because really, when you think about it, a living trust is nothing more than a set of marching orders. This is what I want to have happen if I become incapacitated, or someday when I passed on, this is what I want to have happen. Okay. So the question is, well, gosh, does the trustee, the successor trustees after mom and dad are gone, do they have any liability? And the answer is yes. Because when you're serving as a trustee, you occupy what's called a fiduciary position vis-a-vis the beneficiaries. And the fiduciary duty is the highest duty known to the law. So you are personally liable if you misappropriate funds, or you invested in Enron stock, you didn't look at this, and you didn't talk to, you weren't making smart money choices. The beneficiaries now have an action against you as an individual, as the trustee of the trust. So the goal is, we create the trust. Who are the people that you trust to take care of matters if there's a disability mentally, or someday when you're gone? The people that would step up to the plate and discharge these obligations to your family, or to your ultimate beneficiaries, the people that you did all this planning for. Okay.
It's a huge duty when you think about the person who has to come behind and pay the bills and close the accounts, and they have to manage property, they have to manage tax returns, they have to manage investments. Yep. I would think, boy, you'd really want a good trustee. So what happens if somebody can't find that right person?
Well, there's what's called couple of opportunities here. One is called a private professional fiduciary. That's somebody who basically does that kind of work for a living. Okay, mm-hmm. And it's an individual, and this person, usually they belong to a group called like PFAC, the Professional Fiduciary Association of California. Okay. And so, they're licensed and bonded by the state of California. So there's a pot of money. If they screw something up, there's a way for the beneficiaries to be made whole. Sometimes a corporate fiduciary, so maybe like a bank. A colleague of mine is a banker at Citizens Business Bank. I'm not, this is just an example, but they also have a corporate trust department. So basically, they can be the ones to step in and take over. And maybe, mom and dad say, look, we love all of our kids equally, but you know what, we don't want to put any one of them on the firing line. We're going to leave this in the hands of a private professional fiduciary, or we have a relationship with their bank such that we trust the bank trust department to come in. Now, if you've ever seen old TV, movies on TV, or, the bank trust department officer was, very cold and very aloof and impersonal. That's not anymore. The banks have realized that there is a lot of business to be had. And almost invariably, they're going to bend over backwards to do a great job to work with the beneficiaries as much as they can within the limits of what the living trust says, okay? Because the trust has been set out a certain way. And again, it's the marching orders of what the trustee can do for the beneficiaries and what the beneficiaries are entitled to and when they're entitled to it, et cetera. So, to answer your question, so it can be a private professional fiduciary or it can be a corporate trustee. Just depends on what is their comfort level.
Yeah, I like that. Okay, so kind of one last area, and that is inevitably, there's always something that's not in the trust. I've seen women go to blows over mom's pearls. I thought it was going to break up the family. Someone finally came along and said, cut it in two and restring it. And they went, yay.
Wow.
So how do you, like when people are arguing, and I've seen too, when my girlfriend passed away, she said, go around the house, put stickers on whatever you want. And the kids were coming behind, ripping off stickers and putting their own on. How do you solve these?
Well, here's what we do. A couple things, a couple ideas. One is what's called a specific bequest. So in the trust, clients can say, look, I've got that, maybe dad says, look, I've got that baseball card collection. I want it to go to number one son.
Okay.
Or mom has her Wedgwood china, or Wedgwood, I guess it's Wedgwood crystal. Is it Wedgwood crystal? I forget which it is. Anyway.
Wedgwood.
So she's got some Wedgwood and she wants to leave that to her eldest daughter or to a niece, whatever the case might be. So anyway, and that's one way to take care of that. But for other items like just snacks around the house, et cetera, one idea could be to take painter's tape, stick it on the back of like the painting or whatever, and just say, to Bobby or to Susie or whatever it might be. But, these hijinks do happen. So here's what we do. We prepare for clients what's called a personal property memorandum. Mm-hmm. So I would always tell clients, look, don't ever write on your documents because you could invalidate them and we would hate to see that happen.
Yep.
But documents you can actually write on and you can sign and date them. And so basically it's just a blank list and you can say baseball card collection, Bobby, signed by dad and the date. And it's kept with the portfolio, the estate planning portfolio. So this is evidence to the trustee, dad wanted the baseball card collection to go to Bobby, okay? Or mom wanted her china to go to Susie or whatever. And so that way, it's just a way, and we always load all of the documents that we prepared for the client and have been executed. We put them on a flash drive that is included with the portfolio. So as mom and dad may fill out this personal property memoranda, then they can, if they need more pages, maybe they kind of run out. Well, you can always print off more from the flash drive and now, and just, sign, date, and keep everything together. And that's at least some evidence that, this is what mom and dad wanted to give to. And that should, we hope, prevent fights. Now, sometimes mom and dad don't do that. They don't fill out the stuff. And so to answer the question, well, you can draw straws, flip coins, whatever. Who gets
rock,
what?
Paper, scissors. Yeah.
Exactly. Or, really novel idea, kind of a king, kind of Solomonic wisdom. You just cut the string of pearls in half.
And everybody's happy.
Yeah. So anyways, so hope that helps. Does that answer the question?
Yeah, this does. If you have any bit of advice, pearls of wisdom for our audience, what would you tell them about their estate planning documents?
It's important to get it done. Just get started.
Mm-hmm.
And, if you work with someone like me, the best way to identify an attorney, find an attorney who really focuses on this area. We kind of jokingly call it a door practice. So whatever walks through the door, you take that as a client.
Uh-huh.
Avoid that kind of attorney if you can. If you got through law school, passed the bar exam, we have to assume a certain level of competence. But, my narrow area of the law can get so involved and complicated. You really need someone who's working almost full time in this area to have someone who's good at it. So you can find a good attorney through this. Usually every county has a bar association. They have a lawyer referral and they can give you a half-hour appointment with up to 3 different attorneys to help you find somebody. There is a group that I belong to has a website called estateplanning.com, and you can find an attorney in your local area that way. And these are people who've been pretty well vetted and they know what they're doing, et cetera. And you can have a initial consultation just to see if they're a good fit. And if they are, and if you are, then you can possibly engage that person to do your planning. But I say, and especially we're still in a pandemic, unfortunately. So the healthcare directive and the Hipaa are really important documents to have. But go the rest of the way though. Get a plan in place. If you own real property here in California, Great idea. Do a living trust. Have your home or your rental property owned by your living trust. Have the trustees ready to step up to the plate and make sure that you're taken care of, the assets are managed correctly. And then someday when you pass on, there won't be any probate. There'll still be duties on the part of the trustee to inventory and appraise the assets and make distributions out, et cetera. But there won't be the time and the expense and the publicity of a regular probate, which, happens. It's a choice. It's the default plan of the state of California.
Yeah.
But we get people, educated and motivated to do something while they're alive and while they're well. Okay. So hope that helps. Any other questions that I can answer that might be valuable to share with your listeners?
I think that helps a lot, Rod. I'd like to put a link to our listeners in your show so they can reach out to you, maybe get their wills and trust looked at, make sure that they've got the right people. Does it say what they want them to say? Sure. So you have been just absolutely fun, wonderful, and very knowledgeable. Thank you so much.
It's been a pleasure to spend time with you. I hope this was helpful for your listeners.
Very helpful. Thank you so much.
Advisory services are offered through Barbara J. Norman, LLC, an investment advisor in the states of California and Texas. The information contained herein should in no way be construed or interpreted as a solicitation to sell, nor an offer to sell advisory services to any residents of any state other than the state of California, or where otherwise legally permitted. All content is for information purposes only. It is not intended to provide any tax or legal advice or provide the basis for any financial decisions. The information contained in this material has been derived from sources believed to be reliable, but is not guaranteed as to accuracy and completeness and does not purport to be complete analysis of the materials discussed. The opinions expressed do not necessarily reflect those of SagePath Solutions and are subject to change without notice.